and take all the time you need.
Thank you. Given that the opponents have been given 2 hours and 15 minutes, roughly 3 times what my side has been given, given the 48 total pages that were not revealed to me until 10 a.m. today, I think I will read my testimony into the record. I haven't done that ever in my career, but I will be reading all 8 pages. But before I get there, I think we need to summarize what we've just heard. The bottom line is quite clear. The bishops fully plan on dragging the victims through a constitutional challenge if the statute of limitations is revived. Second, there are a lot of smart lawyers who have a lot of time at their disposal who will be able to help them make their arguments against the victims in court. Third, the Pennsylvania Supreme Court has not yet addressed this specific issue. It has addressed issues around it. It has not addressed this specific issue. It is unfortunate that the prosecutors who have worked very, very hard on grand jury reports and whose lives were changed by learning what has happened with the cover-up of sex abuse were not permitted to testify. Mariana Sorensen is here. Daniel Dye asked to testify. Larry Lewis. All of them asked to testify. They were not permitted, but I appreciate the opportunity for me to testify. Professor Roosevelt and I will represent the University of Pennsylvania contingent. I'm a proud graduate of the University of Pennsylvania, where I was the editor-in-chief of the Law Review, where I clerked for Judge Edward R. Becker, God bless his soul, of the Third Circuit, and for Justice Sandra Day O'Connor. As I say, it is not my style to read, and I have never done it, but I'm going to read every word because it responds to every argument raised, but one, and I will add one sentence with respect to that. Thank you for asking me to testify at this hearing on the constitutionality of HB 1947, which modestly amends Pennsylvania's statutes of limitations for child sex abuse. Unlike the handout that was provided earlier, I am actually a resident senior fellow in the Program for Research on Religion in the Fox Leadership Program at the University of Pennsylvania full-time now. I am co-chair of the Common Ground for the Common Good Project, which is a project that is bringing those in the culture wars together to find common ground for what's good instead of this endless culture war. I am the academic director of Child USA, which is an interdisciplinary think tank on child abuse and neglect. After 26 years of full-time teaching, I am no longer at Cardozo full-time. Instead, I am devoting the rest of my career to child protection at Penn. I am the author of Justice Denied: What America Must Do to Protect Its Children, published by the leading academic press in the world by most accounts, Cambridge University Press. And I operate the website, www.sol-reform.com. I am the only legal academic in the world who has tracked statute of limitations in their reform for the last decade or ever. I have been asked to, and this is not in here, I'll just extemporize for a minute. I've been asked to give advice on statute of limitations in every state where there has been significant improvement, in Scotland, in Japan, in Australia, and many other countries. I have litigated the constitutionality of reviving expired statutes of limitations and won, and I have written pro bono, that's for no pay, amicus briefs in states where it has been challenged again and again. The one opinion that never came up by the opponents of the victims, the one opinion that never came up was the Massachusetts opinion, which is the most recent. That would be the Sliney opinion, S-L-I-N-E-Y. If you read that opinion in the first footnote, it thanks the amicus brief for the assistance in providing the arguments for constitutionality. That was my amicus brief. The this committee has asked me to focus on is whether the revival of a civil SOL for child sex abuse is consistent with the Pennsylvania Constitution. The short answer is that along with a majority of states, I think that the former testifiers have some math problems. A majority of the states, it's constitutional to revive an expired civil statute of limitations. I could not agree more with the Catholic Conference representative up here saying that due process is distinctive from the Remedies Clause. He is absolutely right, and that's why my memo first addresses due process. So let me first set aside the due process issues in this arena. It is unconstitutional to revive a criminal SOL because it violates the ex post facto clause. That is the Stogner v. California case, which was decided after California attempted to revive both criminal and civil statutes of limitations. The United States Supreme Court did not rule on civil. They held the criminal were unconstitutional. So the only thing this state can do right now is to eliminate the criminal statute of limitations for victims that are being abused on the day that the bill is passed and when it becomes effective. You can't put anybody else in jail for your overly short statutes of limitations criminally. So the only option that you have for the majority of people in this room that are well over the 30 of the statute of limitations in Pennsylvania is to revive the civil statute of limitations, and that's why there is a vibrant movement across the United States to revive the civil statute of limitations. It is not a due process violation to revive the civil statute of limitations, as you've heard repeatedly now, and it's refreshing to hear some candor. Landgraf stands for the proposition that under federal law it's constitutional. The revival of a civil statute of limitations is constitutional under federal law if two requirements are met. One, there must be clear legislative intent. And two, the change must be to a procedural element like a statute of limitations. Others have done it, but I will not read the citations. I will refer you to my testimony for the full citations. The precise question of constitutionality of reviving a child sex abuse statute of limitations has not yet been addressed by the Pennsylvania Supreme Court. No one disagrees on that. The court, however, has applied the federal due process principles in the Bible case and in the McDonald case. In the Bible case, it held that a retroactive amendment to the Workers' Compensation Act was constitutional because we have used the same reasonableness, balancing of interest analysis in applying the due process protections of the Pennsylvania Constitution. There we observe that traditionally retrospective laws which have been deemed reasonable are those which impair no contract and disturb no vested right, but only vary remedies, cure defects in proceedings otherwise fair, and do not vary existing obligations contrary to their situation when entered into and when prosecuted. The Pennsylvania Supreme Court's reasoning controls, of course, and in Bible the court found that an amendment which retroactively changed the compensation for loss of hearing for workers' compensation claims did not violate due process. The amendment did not impair a claimant's right to receive any compensation for hearing loss, which would have been a substantive change, but merely changed the remedy and retroactive application of the amendment to pending cases was rational. Any claim to a vested right in the running of a statute of limitations is grounded in a right to due process. And the Pennsylvania Supreme Court has already foreclosed any proper reliance on any due process argument. Most recently, in 2015, two of Pennsylvania's sister state Supreme Courts considered the constitutionality of similar revival legislation. And after careful and comprehensive analysis, both concluded that the revivals were a proper exercise of legislative judgment under their state constitutions. That would be the Sliney opinion in Massachusetts, which has heretofore not been mentioned, and of course the Doe v. Hartford Roman Catholic Diocesan Corp case out of Connecticut. I would add the Sheehan case out of Delaware, but it precedes those two opinions. Those are the two most comprehensive. As under federal law, where the retroactive intent is plain and the statute involves the retroactivity of a civil but not a criminal procedural matter, the revival of a civil statute passes constitutional matter under due process. Pennsylvania follows the same reasoning as the United States Supreme Court and has permitted the retroactive application of statutes under circumstances like HB 1947. In recent years, it has observed the distinction drawn by the federal courts between procedural and substantive changes in the law and prescribed deference with respect to procedural rules. And statutes of limitations are procedural in Pennsylvania, not substantive, and they have been so since Seneca v. Yale in 1941, and of course most recently in McDonald. Since the Supreme Court's articulation of the modern constitutional standard in Landgraf in 97, the retroactive application of lengthened statutes of limitations has not been found to disturb vested rights under Pennsylvania law. To quote McDonald v. Redevelopment Authorization, "No one has a vested right in a statute of limitations or other procedural matters, and the legislature may at any time alter, amend, or repeal such provision without offending constitutional restraints." Earlier, an additional part of that quote was added to the discussion. What the additional part of the quote actually says is that it is unconstitutional to create a cause of action after the time in which the activity occurred. And so it is unconstitutional to create a cause of action, but it is not unconstitutional if the cause of action existed at the time of the crime and the tort to change the statute of limitations. As you are well aware from the previous testimony, there's no problem with shortening a plaintiff's claims. The question before us is whether or not a plaintiff can have the benefit of extension. In McDonald, which involves statutes of limitations under eminent domain, the court held that a retroactive restriction and limitations period from 5 years to 1 did not violate the plaintiff's due process rights. In other words, the shortening of an SOL for a plaintiff was permissible because it was just a procedural change, not a substantive change. The same reasoning applies to defendants in this case and thus to HB 1947. Mere alteration of an SOL does not violate due process in Pennsylvania. It's thus in the line with the majority of states which have not found that defendants have a vested right in expired SOLs post-Landgraf. And I commend to you the over half-page string cite of the majority of states which have refused to find a constitutional violation in revival of a civil SOL. Pennsylvania courts have thus observed a distinction, even in the sovereign immunity context, between retroactive application of a legislative procedural enactment, such as revival of an SOL, and actual retrospective or retroactive laws which might violate either the due process clause or ex post facto. Expressly following Landgraf, one Pennsylvania court has reasoned as follows. A statute does not operate retrospectively merely because it is applied in a case arising from conduct antedating the statute's enactment or upsets expectations based on prior law. Instead, the court must ask whether the new provision attaches new legal consequences to events completed before its enactment. A statute is retroactive only if it changes the legal consequences of acts completed before its effective date. The amendments do not impair rights a party possessed when he acted, increase a party's liability for past conduct, or impose new duties with respect to transactions already completed. As such, those don't operate retroactively. Furthermore, as our Supreme Court has explained, the modified timing requirements are procedural and therefore do not fall within the categories of retrospective laws prohibited by the ex post facto clause. That is a 1999 case, Commonwealth v. Johnson. But just to explain what I just read, the bishops knew when they covered up for pedophiles that crimes were being committed. They knew, sadly, that hundreds of children were being sexually assaulted by their own priests and employees. They knew that it is a tort to endanger children. So they knew all of that at the time that they took these actions that would be covered up to age 50, which is the modest bill that HB 1947 is. So there's nothing unfair in saying the bishops can be sued for what they knew was criminal and tortious. One of the reasons, let me go back. So consistent with the above reasoning by the Pennsylvania Supreme Court, HB 1947 does not retroactively alter the burdens on the parties or the penalties for defendants who commit or create the conditions for the sexual abuse of children at the time of the commission of the offense. It merely changes one procedural element of the civil law governing child sex abuse, the timing of bringing the civil lawsuit. Nothing else has changed, and the victims still have their burdens of proof. One of the reasons given for due process arguments against revival of SOLs is a stated concern about the potential for false claims. This argument, of course, is a red herring in this arena. Victims of child sex abuse rarely make false claims, as we learned in California and Delaware, where windows already opened and closed. In California, there were anecdotal but unconfirmed reports of approximately 5 false claims out of the 1,150 filed out of a population of 35 million people, which means false claims in the area of child sex abuse are statistically insignificant. In addition, numerous scientific studies have established that children rarely make up child sex abuse. While there were few false claims in California, the window resulted in the identification of 300 child predators previously unidentified to the public. And I do find it entertaining that the bishops are very fond of pointing out, but 150 of those predators had died. So the California bill only identified 150 predators yet unknown at the time of the filing of the open window. These numbers, when applied to the due process, reasonableness, balancing of interest analysis articulated by the Pennsylvania Supreme Court and Bible, also weighs in favor of deference to your judgment, your legislative judgment for protection of children under the land-grant framework. Opponents of reform further try to claim that without a statute of limitations, institutions and pedophiles won't be able to defend themselves in court against decades-old claims, thus also raising due process fairness concerns. This is another red herring. SOL reform does nothing more than remove an arbitrary deadline for filing a claim. The plaintiff still bears the initial burden of proof, and if the plaintiff does not have corroborating evidence, the case is over. And I regret that Senator Boscola is not here. It was shocking to hear anyone in 2016 say that there's not corroborating evidence in civil cases. There is frequently corroborating evidence in civil cases, and experts like the leading child traumatologist in the United States at the University of Pennsylvania, Stephen Berkowitz, could have testified to explain to you that corroboration of a civil claim is very common. Right now, for the majority of cases in Pennsylvania, institutions and pedophiles simply file motions to dismiss solely on SOL grounds. They fear that the cases will now move on to the merits rather than remain unheard due to this arbitrary deadline. All we're talking about is a deadline for going to court. We're not talking about anything else in the case. As the Landgraf Court noted in discussing the reasonableness of retroactive legislation as related to tort claims, there is no such thing as a vested right to do wrong. This principle has long existed under Pennsylvania law as well. There is no such thing as a vested right to commit a wrong nor to cover up a crime, as the Pennsylvania Supreme Court said in 1902 and as early as 1827. Where the defendant would be claiming a vested right arising out of the very same procedural problem which motivated the legislature to act, due process concerns are muted, and fundamental fairness cuts in favor of retroactive reach intended to cure the wrong. As Gilman said in federal court in 1923, there can be no vested right to do wrong. Claims contrary to justice and equity cannot be regarded as of that character. Consent to remedy the wrong is to be presumed. The key distinction is that the pedophile and the aiding and abetting institutional defendants knew full well when they endangered and harmed children that they were violating the law. There is no unfair surprise in subjecting them to liability because when they acted, they were on full notice that they should not have done what they did. and that is why they had insurance coverage. The revival will do no more than impose on them the liability they created through their own wrongful actions at the time they acted wrongfully. Heading 2. The plain language of the Pennsylvania Remedies Clause protects those who are injured, not those who have caused the injury. I find it quite remarkable that at a hearing in which the focus has been on the Remedies Clause, and that is the primary argument for the opponents, no one has bothered to note the language of the Remedies Clause. Aware of the foregoing law and due process and that they have a losing claim, the Catholic bishops and their big business supporters have now fallen back on an alternative theory that the Remedies Clause of the state constitution supposedly bars revival of a cause of action in order to protect tortious defendants. The purpose of the Remedies Clause, which is derived from the Magna Carta, which is the seed of our Constitution, was to protect plaintiffs from legislative action that will undermine the existence of a remedy for an injury that was done. It is a constitutional guarantee of open courts. Many states call their Remedies Clause provisions open courts provisions. It is not a shield to block court access in favor of powerful defendants. Unlike a general due process concern, which must be applied to either party, the Remedies Clause text limits its own application. And this is the language of the Remedies Clause which controls, as the Pennsylvania Supreme Court has said, the plain language of the Constitution controls. All courts shall be open, and every man for an injury done him in his lands, goods, person, or reputation shall have remedy by due course of law, and right and justice administered without sale, denial, or delay. Suits may be brought against the Commonwealth in such manner, in such courts, and in such cases as the legislature may by law direct. Just by way of background, it's not in my testimony, but I think it's worth explaining. Under the Articles of Confederation, the state legislatures became vortices of corruption, which is precisely what Madison called them in the notes of the debates of the Constitutional Convention. The Remedies Clause was intended to turn state representatives into people who would be accountable to the people and not to just moneyed interests. That is simply the history of the United States Constitution. The Remedies Clause reflects the desire to give the little guy a chance, even when they are not being heard. They get to go to court. With HB 1947, the legislature is simply trying to protect a plaintiff's ability to proceed in court in pursuit of a remedy for the injury that has already been done. This bill does not create a new substantive theory, but rather makes it possible for the one who was injured to receive due course of law. And I couldn't agree more that due course of law is different from due process. All Pennsylvania courts agree that the legislative branch cannot dissolve a right to recover once a case accrues. Cannot dissolve a right to recover. Just so you understand, if the Remedies Clause were removed from the Pennsylvania state constitution, that would mean that the state legislature could deprive plaintiffs of claims they have at the time they were wronged. That's what the Remedies Clause does. It's protected plaintiffs from not being harmed. The bill does not create this new substantive theory, and all Pennsylvania courts agree that the legislative branch cannot dissolve a right to recover once a case accrues. It's a right to recover for a harm done. If at that moment in a particular case, the law would provide the plaintiff access to a remedy, no subsequent law can take it away. So the operative question under the Remedies Clause is whether someone has been injured. And the argument that's being raised by the 2 hours and 15 minutes in opposition to HB 1947's revival is essentially that it's unfair to the defendants for them to have to be accountable for what they knew was wrong. That it's unfair to them. But the language of the Remedies Clause goes for those who are injured. The bishops and all those other institutions that have harmed our children in the state of Pennsylvania, those bishops are simply not injured. In Iropoli v. ACNS Corp., the Pennsylvania Supreme Court held that the statute limiting successor asbestos-related liabilities for corporations was unconstitutional. The court analyzed the history of the Remedies Clause in Pennsylvania and found that the legislation violated the Remedies Clause because it extinguished the plaintiff's accrued cause of action to recover for his asbestos-related illness. In other words, the statute was trying to take away from the plaintiff any claim that the plaintiff had. The Iropoli court held that under the Remedies Clause, a cause of action that is accrued is a vested right which cannot be eliminated by subsequent legislation. Any academic attempt to broaden the Iropoli holding or reasoning to include tortious defendants who have harmed others is belied by the words of the Pennsylvania Supreme Court itself, which in considering a narrowing legislative reenactment in response to Iropoli, restated its own Iropoli holding as follows. We held that the statute was unconstitutional as applied retroactively, as applied to complaints filed before its effective date, because the statute extinguished already existing causes of action. According to the Pennsylvania Supreme Court, the guarantee of a remedy by due course of law in Article 1, Section 2 means that a case cannot be altered in its substance by a subsequent law. Procedural changes are not constitutionally problematic under the Remedies Clause, and statutes of limitations are procedural in Pennsylvania, not substantive, as Seneca v. Yale determined in 1941. Given the due process holdings of cases such as Bible and McDonald, it does not follow that Iropoli or Conadaris alter the text of the Remedies Clause to make it apply to not only those injured, but also those responsible for the injury. There is no vested right to do wrong in Pennsylvania. Kiskaden v. Dodds, 1902. Thus, the plain language of the Remedies Clause should control. There is no legitimate, much less plain reading of HB 1947, whereby child sex abuse victims can be said to be the cause of injury done to the institutions and the individuals who endangered them. The words and phrases of the statute shall be construed according to the rules of grammar, and that is what HB 1947 says. In the interest of a full explanation, it should be noted that there is one very old case which contains dictum that all of my prior fellow panelists have relied upon, Lewis v. Pennsylvania Railway Company. Unfortunately for their theory, the actual facts of that case are decidedly different from HB 1947, and that's one of the reasons that HB 1947 was crafted the way it was in light of Pennsylvania's Supreme Court law. In that case, a man who worked as a poleman died, and his wife sued the railroad because it was an accident. And at the time that he died, the only people who could sue under state law were those who were riding on the train. Employees were blocked from suing at the time that he died. And so later, Pennsylvania actually enacted a law saying that if you were an employee, you too could bring a claim, not just the ones who were in the carriage. And the widow said that I have the right to a remedy to a substantive law that was not in effect at the time that my husband died, and she lost. She lost because Pennsylvania changed the theory, the substance, and when he died, they had no rights. And so the question in all of these cases for the victims is, at the time of their abuse, did they have a claim? And the answer is yes. And so reviving the statute of limitations does not conflict with Lewis in any way. And one state after another to consider this issue, starting in California all the way up through Massachusetts, has rejected that conflation of substance and procedure. Given the due process holdings of cases such as Bible and McDonald, it does not follow, in the interest of a full explanation, Lewis, as I just explained, is irrelevant. Lewis was actually distinguished by the Supreme Court of Pennsylvania in 2008 in Conaderas. In that case, the Supreme Court of Pennsylvania held that a retroactive amendment to Municipal Claims and Tax Liens Act to provide for recovery of attorney's fees expended in collecting tax claims did not violate the Remedies Clause of the Constitution. The court reasoned that the 2003 retroactive amendment to the MCTLA did not violate it because the constitutional protection contained in the clause is for a remedy for an injury done, and there was no injury done. Finally, once again, there is no vested right to do wrong in Pennsylvania. This rule has long existed. Although after reviewing both longstanding precedent and modern jurisprudence, not only in this state, but in all 50 states which I have tracked, I am persuaded that civil SOL revival legislation, if enacted, would be a proper exercise of legislative judgment in the state of Pennsylvania. But the only way to have this question answered once and for all is to enact HB 1947 with its retroactive revival provision. And when the defendants drag the victims through appealing the constitutionality of HB 1947, allow the justices of the Supreme Court of Pennsylvania to answer the question themselves. Under Pennsylvania law, as under federal, any legislative enactment enjoys a presumption of constitutionality. Those who wish to challenge it bear a very heavy burden to prove it unconstitutional, and a statute will only be declared unconstitutional if it is clearly, palpably, and plainly in violation of the Constitution, which cannot be said about the Remedies Clause. Pennsylvania's children and adult survivors deserve at least this much respect. My final point is quite simple. The argument has been made over the years that the Pennsylvania Remedies Clause is distinct. Pennsylvania is distinct, but under the Pennsylvania Supreme Court's reasoning itself, it reflects the constitutions of 39 states that are substantially similar. This provision, this is from the Pennsylvania Supreme Court. This provision, commonly referred to as the Open Courts or Remedies Clause, is derived from Magna Carta and Sir Edward Coke's 17th century commentary on the Great Charter, which was relied upon by the drafters of early American state constitutions. As a majority of state constitutions contain plaintiffs' remedy clauses similar to Pennsylvania's, and a majority of states have found revival of civil statutes of limitations not to disturb any vested right, it is disingenuous to argue that Pennsylvania's Constitution is somehow distinctive on this issue, and thus would somehow require a contrary result from that seemingly dictated by the ordinary, commonly understood meaning of the term open courts. I sincerely hope that this testimony has clarified these issues for you and welcome your questions. Finally, on a personal note, I have many close ties to Pennsylvania, where I have lived for over half of my life in Bucks County. I'm a proud graduate of the University of Pennsylvania Law School, where I served as editor-in-chief, of the Graduate School of Penn State University, where I received distinction in philosophy and English. I clerked for Judge Becker. My husband, Peter Kuzma, a cradle-to-grave Catholic, has operated a successful chemical company, VIP Products Corp. In Philadelphia for over 40 years. He graduated from St. Joe's University, Archbishop Wood High School, and Our Lady of Good Counsel before obtaining his PhD in organic chemistry. Both of our children were valedictorians in their classes at Council Rock North High School, which prepared them for high achievement at highly competitive colleges. We are blessed to live in this beautiful state. The last point I would add is simply to respond to the point about Plout v. Spendthrift. Plout v. Spendthrift does not stand for the proposition that it's unconstitutional under the federal Constitution to revive an expired civil statute of limitations, because in that case, the decision below was based on the merits and on the statute of limitations. Plout has been rejected in terms of civil statutes of limitations in the states where they have upheld a revival. And so it does not assist, which is why it's not in my testimony. I'm more than happy to take any questions that you have.
Senator Rushton-Slider.
Thanks, Mr. Chairman. Thanks, Professor, for coming in. I just want to take a step back and look at public policy. From some statistics that were provided to us, it appears that 83% of children in Pennsylvania go to public schools. And from my understanding, there's a cap of $250,000 on those damages, which I think is completely, just way too low, completely insufficient. What would your thoughts be on an amendment to this bill to do away with a cap on the public school damages?
As I've written in Justice Denied, the right policy is to eliminate the statute of limitations for child sex abuse in every category. Children have no defense to the predators. And so I would fully support an amendment to this bill that would eliminate the current caps in the public schools. But I'd also point out that the public schools were mandated reporters for a very long time. We recently had a scandal in Council Rock, which was tragic because one of the teachers in Council Rock South was taking a girl home and tutoring her. He destroyed her life. And it turned out some of the teachers learned about it before anybody else. As soon as the superintendent heard about it, he held a meeting of the entire faculty of all the schools of Council Rock. And he announced that the teachers who had not reported the abuse would be fired. And they should have been and were. So the schools have been stepping up. They have been required reporters. Why hasn't the church? Why haven't the religious institutions been required reporters? Because they have lobbied against mandated reporting in every state. And they, until very recently, have won in most states. So the two arenas are different. They're always handled differently for tort purposes, but I would fully endorse and be willing to testify in favor of bringing the children in the public schools to some kind of justice. But what we do know is after 10 years of looking at this in the state of Pennsylvania, and you've heard from the vast majority of the many, many victims sitting in this room, we know what's going on in the private institutions. And so far, the state has done nothing.
Thanks, Professor.
Senator.
I did not know this man, other than testifying on the task force, but I didn't know him personally. Jason Kukalakis, if I said his name right, are you familiar with a letter that he wrote describing his position on this, dated March of 2013?
Yes, I'm very aware of that letter. It was shared with me recently.
Oh, you didn't see it before that?
Oh, no one sent it to me. Why would they send it to me? I might rebut it.
I don't know. This is supposed to be about the kids, so.
It is supposed to be about children.
Right. So now that you've been shared this piece of this letter and his position, what do you disagree with? All of it in his arguments about the statute of limitations? Is there anything you agree with in what he says?
I am hardly going to testify to that kind of a question. If you'd like to ask me a specific question from his arguments, I would be happy to answer.
Well,
but his arguments are not very different from the ones you've already heard today.
Well, then there's your answer.
That's my answer.
Okay, that's fine. You also say that the only way to really solve this is to pass it to judge it. In other words, let's pass it and let's send it to the courts and let them make a decision. Do you think that's the way we should do things in the legislature? If we believe that this is truly unconstitutional from everything we heard, you still support the idea that we should pass it and send it to the courts for them to judge? Because this is the issue we're dealing with up here.
No, I understand. And my view is that the law is clear. The Pennsylvania Supreme Court has not yet ruled on this. And so as one of the prior testifiers stated, you don't know what the Pennsylvania Supreme Court will do. And so I don't understand how this committee would know that it's unconstitutional if the Pennsylvania Supreme Court has not ruled on this issue yet. It's clear there are arguments that can be raised on both sides. There's no question, arguments can be raised on both sides. And in that circumstance, I think normally legislatures pursue what they believe to be justice and the right policy, rather than holding it.
Even if they think it's unconstitutional that's why we're holding this hearing today, to determine, is it unconstitutional or not, and it's our opinion. It's not a judgment we can make. I myself, I'm not an attorney, former police officer, but it is a tough issue, and when you read something like Mr. Kukalakis wrote, and knowing that his respect in the community here, it hits home to you as far as trying to make a judgment on this. You said that.
May I just say one thing
Yes.
in response to that?
Yes.
In the 19th and 20th centuries, it would have been unconstitutional under federal and state law, and he would have been correct. But the law has dramatically changed in the last century, and there are no cases in his memo that are recent. And so what I would ask you, as a non-lawyer, I'm married to a non-lawyer, we debate these issues every single night, I'd ask you to think about the civil rights movement. I'd ask you to think about the fact that when Congress passed the 1964 Civil Rights Act, there were many, many people who said it was unconstitutional, and they still passed it. And then it was upheld by the Supreme Court in a controversial decision. This is a civil rights movement for children. We're finally not treating children like property. And so I urge this body to have respect for human rights and children's civil rights and to let the courts decide.
Well, I guess everything evolves. It's just we're now doing some different things with sentencing. We were very strict. Now we're getting a little bit more lenient. We're trying to make tough decisions on that. We have this issue right now. We talk about the remedies clause, but you said the remedies clause is really there to protect the injured.
That's what the language of the clause says. Someone who has been injured.
Okay. But the federal government doesn't have a remedies clause.
That's true. It does not.
Or are we better off with following the language of the U.S. Constitution, where it doesn't have something specifically in there to protect the injured?
Well, I mean, obviously, this body is bound by both the United States Constitution and the Pennsylvania Constitution. On due process, the language is identical, and of course, they are the same, and that's why there's no due process problem. The only possible argument is this remedies clause argument, and that's where the debate has been, and that's where the Pennsylvania Supreme Court has not clearly ruled, but there's a lot of precedent on the side of saying it would be constitutional. If this body wanted to help victims, it could. It's very simple. It's very, very simple.
I wish it was. We disagree on that. This is a decision that we have to make as lawmakers, but would you say that it'd be more favorable we didn't have a statute of limitations and we just...
For child sex abuse, absolutely.
Okay. For anything else?
Everything else, it makes sense. We have a wide range of statutes of limitations. On property ownership, we have relatively short statutes of limitation. On Contract disputes, we have short statutes of limitations. We have clear statutes of limitations on property ownership because we need to know as a market economy who owns what, whose rights are financially protected. We have no statute of limitations on murder. And in between, we have everything in between. And what we've been experiencing in the last 25 years in the United States and across the world is that every time a date is set for child sex abuse statute of limitations, it turns out to be unjust, and it needs to be amended. And so Pennsylvania is not unlike the rest of the country. Just keep, repeatedly amending the statute of limitations. But it's pretty clear that the end game is where Delaware landed, which is to eliminate both civil and criminal, get a window in place that will provide the ability for victims to come forward and tell you that Dr. Earl Bradley has abused 1,000 children, and then move forward. That's the tide of the law, and Pennsylvania is now far, far, far behind that tide.
Procedural versus substantive. Basically, you're saying this is a procedural move.
This is a procedural change.
Which is allowed.
Yes.
Substantive. How does that play into the discussion when they're trying to compare the two? Is substantive just the some action you take, or is it a result of the procedure?
Well, the way that the courts have drawn this line in, which is due process essentially, the way the courts have drawn the line is they have said certain things are procedural, and that gives you all wide latitude, and certain things are substantive, and you can't change those retroactively. Substantive is the substance of the cause of action, right? So if at the time of the abuse it wasn't illegal for a child to be sexually abused, or at that time if it was okay to have one of your employees put near a child when you knew they had sexually abused a child, if that had been legal, you couldn't do revival. But it's always been illegal to sexually abuse a child. And so that argument fails. And so there's no substantive change. And unfortunately for the victims, they have to fight in this process, and then they have to go to court and fight and prove their case up. They have to have corroborating evidence. They have to have experts. They have to have their mothers testify that they fell apart and became addicts. That's what they have to go through. And so what this hearing today is, unfortunately, is another gauntlet for the people sitting in this room and the thousands sitting across the state waiting eagerly to hear what you're going to do.
One last question, Mr. Chairman. How many people do you feel are waiting for this to pass so that they can take advantage of this open window and file suits?
And that's a very fair question. Having studied all of the revival statutes across the country, very small numbers come forward. So as I said, in California, 1,150 came forward in a one-year period, and that was out of 35 million people in the state. It's just a tiny number of people. And the reason for that is, one, the good news is many survivors are thriving and had the kind of support system they deserved and they needed, and they are okay, and they're not going to sue. About a third have severe PTSD, and so those are the ones that need some kind of opening, but so many of them are disabled they can't go to court. And so the numbers that will actually bring claims are small, but they are enough that we'll learn about hidden predators we didn't know about before. And they're enough that the ones who really, really need the shift in the cost of the abuse away from them to the ones who caused it will be served. But under HB 1947, it only goes up to age 50. And we know that many of the victims of Stanley Ganna, one of the most disgusting pedophiles from Philadelphia, they're all over 50. They're being cut out by the age 50. So, the bill that you're considering now and debating is such a modest bill compared to what's been done in Minnesota, Hawaii, Delaware, and California. And The church has protected itself with the age 50.
Are there any other institutions other than the church? You mentioned churches all the time. Is there anything else? Is there private schools or?
Yeah.
Because all you've mentioned is churches.
Yes, there's a pending grand jury report coming out about the Soulberry School in New Hope, Pennsylvania, where the founder of the school was the first one to abuse children. And girls have been abused ever since. The grand jury heard testimony from dozens of women who were sexually assaulted at that school. That grand jury report has not come out. I don't understand why. It's been going on for a very long time, but it will. Of course, we know about Penn State, but Penn State is just the tip of the iceberg in terms of sports. We have abuse across the board, whether it's speed skating, judo, swimming, track and field. It's across the board. We have abuse in private schools that's run rampant, as we know from the Horace Mann Action Coalition, which did a national survey. So yes, no one's being targeted here, and the only ones who are going to be sued are the ones who covered up for the predators. And in some cases, the family victims will have a chance because the one who sexually assaulted them is wealthy. But other than that, this is still just a halfway measure to what needs to be done for these victims.
Thank you, Mr. Chairman.
Thank you.
Just a few more questions. Professor Hamilton, were you saying that we should do away with all the statute of limitations for crimes on someone's person? Is that?
No, child sex abuse. It's different.
But I thought you were also just saying that in general statute of limitations, there's a movement to do away with them when it involves certain crimes. I could have sworn you were saying that. I just wanted to get clarity.
No, it's with respect to child sex abuse because the victim has no power. And the science of child sex abuse is increasing daily. As I said, Steve Berkowitz at Penn is absolutely remarkable. He's my partner in starting this think tank on child abuse and neglect. And what he'll tell you is that the traumatology science is getting so good that we do know it's just a fact. Victims need decades to come forward. Some don't, but many, many, many do. It's just a scientific fact.
Okay. And then you keep saying that the case law is old, and you talked about Conadaris. Might be saying that, not pronouncing that correctly, but that's a 2008 Supreme Court case. And
Oh, no, Conadaris, I believe, is on my side, but Lewis is the old case that's being trotted out, and I distinguished it because it's not similar.
well, how do you reconcile the fact that the court there said that the date the law is frozen for a case is the date the injury occurs, and thus the date the cause of action, relevant defense accrues? I mean, how do you
Because the
reconcile
question
that?
is, what was the substantive law at the time of the event? That's the question.
Okay.
And Conadaris agrees with that.
And you're completely throwing out the fact that once that statute of limitation accrues, that it's not a vested right?
That's right.
Okay.
Senator Rafferty.
Thank you, Mr. Chairman. Mr. Chairman, it's a very difficult situation, and thank you for having the hearing today. Thank you, Professor, for testifying. And I'm most anxious to support my colleague's amendment, even though I did remind him that public institutions do fare a bit better in that they have 1983 actions and Title IX actions that could be brought where the private institutions don't have those. However, this is a heinous crime that we've seen in public and private institutions, not just the church. So I want to make that very clear.
Absolutely.
Public and private institutions. And I think that it's incumbent upon us to consider this situation and the legislation before us, and I commend the state representative for his legislation, and talk about the amendments that may want to be offered, like making it fair grounds for private and public, which I'll support, Guy. It's certainly an issue where there's very, very smart people on the other side of the issue. And I'm one of those who believes that this might be a case of first impression, and it's best to be left to the courts. And old-fashioned, I guess, but I believe that constitutional and unconstitutional decisions are best made by those wearing the black robes. So I think that this is something that I'm going to consider going forward, and I'll be anxious to hear the discussion by my colleagues as we debate this House bill and where we should go and what direction we should take. But I do think it's one that's vitally important, critically important for us as the Senate to act on, and to act in concert with the House and see if we can get the kids in Pennsylvania protected. Thank you very much.
Thank you.
Okay, that concludes one comment, though. I want to clarify the fact that we were never asked to anyone who wanted to testify. We try to limit this hearing on the legal issue of constitutionality. We cannot go forward with the bills, and which I think many of us support, without resolving that issue. It doesn't do anybody any good to pass a bill that may be unconstitutional. I know your position. I know the other's position. We have to take that in consideration, then going forward with the bill.
I was just pointing out that prosecutors sitting in the room right now are all in support of the bill because they saw the tragedy with the grand jury reports.
Right. So we're going to go forward with this and deal with this issue, and we would been welcome to have any other individuals that you wanted to testify here. And I know it's hard to get when your main witness is not available, but we were available for any other witnesses you might have had in that regard, the legal issues.
Okay.
Thank you so much.
Thank you.
Thank you.